Okay, so we've been looking at the trial court system this week. We start off by looking at an actual trial itself. What are the sides in a trial? We talked about the steps of a trial. We looked at the appeals court as well as some other courts under the trial court umbrella. Today, we are going to talk about the highest federal court as well as the highest court of appeal in the country, the Supreme Court of the United States. And it's pretty appropriate that we talk about it this week, given we've just had the passing of a Supreme Court Justice, Ruth Bader Ginsburg. So it's pretty appropriate that we go through this information this week. Now, the Supreme Court of the United States, since it is the highest court of the land, it should come as no surprise, it establishes the most important legal precedents. Okay, there are 9 justices on the court, and the majority rules. When decisions are made, the majority rules. All state and federal courts in the United States must follow the Supreme Court precedents. Okay. Now, how they determine to do that is up to them, but they must follow it. Okay. So, for example, with Plessy versus Ferguson, separate faculties had to be equal. However, if you did not have separate faculties, like in the North, okay, you didn't have to worry about them equal. All right. So that's why I say you have to follow Supreme Court rulings. So if you had separate faculties for different races, then you had to make sure they were equal. However, if you didn't have separate faculties, then you didn't have to worry about them being equal because everybody had access to the same stuff. Okay. So, but you have to follow U.S. Supreme Court precedents. We have very little understanding of how the court operates. Okay. Of the 3 branches of government, most people have no idea how the U.S. Supreme Court operates. We are concerned more with the president and with Congress. Okay. Now, the first thing to remember about the U.S. Supreme Court is it does not have to accept all appeals. Okay. It is a court of appeal. It deals with issues that have implications for the entire country, but it does not have to accept all appeals. Okay. That is the most important thing that you have to understand as we move forward here. All right. The Supreme Court does not have to hear a case appeal to it, it sets its own agenda. Okay. And we already talked about for an appeal to succeed, there has to be a major error of the law. Okay. But even if there is, the Supreme Court can still decide, I don't want to hear it. Okay. Now, how do we get to the Supreme Court? It all starts with a petition of certiorari. Okay. Petition of certiorari, and be sure you get this down, is a request of a lower court to send up its records. Okay. So this is just the request to have it looked at by the Supreme Court. Supreme Court still hasn't made a decision whether or not they're going to hear it or not. This is just a request. And it costs $300. Okay. So if you want to appeal to the Supreme Court, you already have to shell out $300 to the court. Okay. Now, the court will accept this petition if lower courts have decided the same issue differently. So if you appeal to one court and they upheld the conviction, and then you appeal to another court and the other side appealed to another court, and that court overturned the decision, there's inconsistency. The court is probably going to want to hear that case to see what's going on. Okay, so a petition is accepted if lower courts have decided the same issue differently, or if we're talking about critical national issues. Okay, so right off the bat, you pay $300 for a petition to have your records sent up to the Supreme Court. Then the Supreme Court will make a decision from there. Okay, they will usually accept a request if lower courts have decided an issue differently, or if they see a critical national issue involved. Okay. All right. So we paid our $300. The court has decided they're going to hear our case. What happens next? All right. The losing side is going to request in writing that the court hear the case and emphasize why the case should be heard, not how it should be decided, but why it should be heard. Okay, and that comes from the losing side. The winning side is going to submit a brief arguing why the case should not be heard. Again, not how it should be decided, but this is why it should not be heard. We followed the lesson of the law. We followed the law to the T. We followed all these precedents, and you should not have to worry about hearing this case again. Okay, that's what the winning side is going to submit. All right. Now, if the appeal, all right, so we paid our $300. Here come the records. The losing side has submitted their request. The winning side has submitted their request. It now goes to the judges. If 4 out of 9 justices agree to hear the case, the petition of certiorari will be granted, okay, and we move forward. If not, that's where it ends, okay? And keep in mind, you've paid your $300, all right? So you're already out $300. So if 4 out of 9 justices agree to hear the case, now notice this is one less than the majority, okay? So it is much easier to get your case heard than maybe to get it overturned, all right? So if appealing party gets 4 out of 9 justices agree to hear the case, then the petition of certiorari is granted and we move forward, okay? Both sides then write briefs arguing how the case should be decided, all right? So we didn't mention rulings earlier. We just wanted to talk about should it be heard or should it not be heard. Now we've gotten our petition granted. Now we're going to say, hey, you guys on the Supreme Court, this is how we think the case should be decided. Now, after you get those briefs, okay, those briefs are sent to the justices, then there's an hour-long oral argument, okay? Each side gets 30 minutes, and it's open to the public, all right? And not only are they going to summarize what is in their brief, okay, what is in their petition, but they're going to be answering questions from the justices, okay? Because there is no jury, all right? It's going to be handled by the justices, all right? So each side has written their brief. They get to appear before the judges, 9 of them, for 30 minutes, an hour-long argument, and the public can come. Then the justices, like I said, the justices ask the lawyers many questions, right? Then they're going to meet in private conference to discuss the case, okay? And the process of drafting an opinion begins, all right? By the way, you need to get down the steps of petitioning the Supreme Court, okay? This is where those dissenting and concurring opinions, the majority wins, okay? So 5 out of 9 justices have to agree. If the dissenting justices want to write a dissenting opinion, I disagree with the ruling and this is why, they can. Also, the justices that agree to the ruling can agree for different reasons. They can write the concurring opinion, okay? I agree with the decision, but I agree with it on this ground, okay? That's when these opinions come out, all right? And again, majority wins. Right. Now, just some fun facts about the Supreme Court. The federal government participates in a significant number of cases. Okay. The Solicitor General's office represents the United States in court. The Supreme Court begins its term on the first Monday of each October and goes through the end of June the following year. Okay. So it is scheduled, not this Monday, but next Monday, the court should begin hearing cases. However, because there is a justice that has passed away, they probably will not begin their session because they will not have, if there's a tie, I don't think they will begin their session because I think they need 9 justices for the majority decision. Okay, so I'm not sure they will begin on time this year. In more than half of the cases, the lower court opinion is reversed. Okay, so you got about a 50-50 shot of winning your appeal in front of the Supreme Court. Justices are nominated by the president and confirmed by the Senate, okay, which is becoming a very, very hot button issue, not just now, but also with the previous justice as well. Okay, they are nominated by the president, confirmed by the Senate. And justices serve for life unless they resign or are impeached. Okay, and there have been justices that have resigned due to medical issues. Okay. The Supreme Court, we've talked about this before, is charged with interpreting the meaning of the Constitution and federal law. All lower courts have to follow these interpretations. Now, I want you to get down the next term. It is a term called stare decisis. Okay? Stare decisis is the rule that a precedent must be followed. It means to stand by that which is decided. This gives our legal system predictability and stability. Okay, so when we say lower courts have to follow the interpretation of the U.S. Constitution, this is why. Okay, because we want our entire legal system to be predictable and stable. It doesn't look good if states ignore the rulings of the highest federal court and the highest federal court of appeals. Okay? Our system will break down. So you've got to obey those precedents. The Supreme Court often deals with very, very controversial issues like the death penalty, freedom of speech, and civil rights. It is not an easy court to deal with because of these issues, okay? We are dealing with some very, very hot button issues. That's why they are so important, but it's why the court is so important. But it's also why it can be kind of difficult because we're dealing with such controversial issues. The Supreme Court has the power to overturn a rule of law established in a prior case. Okay, and we looked at that again with Plessy versus Ferguson, Brown versus Board of Education, and with the prohibition cases. Okay. This occurs when society's prevailing views change and the justices want the law to reflect these changes, or when new justices are appointed who disagree with prior decisions. Okay, and the example I've given is Plessy versus Ferguson and Brown versus Board of Education. Okay, and we talked about this before. Some of those dissenting opinions can become the majority opinion if the court changes its makeup. Okay, and in some cases, future courts go back to some of these dissenting opinions and say, we want this one now as the majority opinion. Okay, and in that case, that becomes the precedent. All right, so oftentimes it will change based on changes in prevailing views in society. Now, I want to talk briefly about international courts. Okay, our big court is the Supreme Court. I'm going to talk briefly about international courts. I'm going to fly through this really, really quickly. International courts are handled by the United Nations. You have two major international courts. One is the International Court of Justice, the ICJ. It is the first and most important judicial organ of the UN. Okay, it came about in part because of the trial at Nuremberg after World War II. Okay, the idea that we need an international court of justice to handle issues like war crimes. Okay, it is headquartered in The Hague in the Netherlands. It settles disputes based on international law that countries submit to it. Okay, and both countries involved must agree to have the ICJ settle the dispute. Okay, so if one country doesn't want the International Court of Justice to handle the dispute, it doesn't go forward. Okay, both countries have to agree to have the ICJ settle the dispute. Another international court that is an offshoot of this is the International Criminal Court, which was created in 1998, but it didn't begin operating until 2003. It has jurisdiction to try individuals for crimes such as genocide, crimes against humanity, war crimes, and crimes of aggression. Now, notice it was created in 1998, but it didn't begin operating until 2003. What happened between 1998 and 2003 that might have caused this ICC to finally get geared up and going? September 11th, 2001, and the resulting wars that occurred after that had a direct impact on the International Criminal Court to begin operating in 2003 after the September 11th attacks in 2001. Now, we've talked a lot about courts. We've talked about trial courts. We've talked about state courts. We've talked about federal courts. We talked about tribal courts. We talked about international courts. The last slide here, the bottom line, and I want you to get this down, no matter what type of court we are talking about, The key element of a democracy is that the courts must act impartially and make fair decisions without undue influence by outside forces, no matter which court we have been talking about. It's got to act impartially to make fair decisions without undue influence by outside forces. In fact, that's why precedent is so important. And that's why we make a big deal about courts obeying precedent from higher courts, because those precedents were made impartially and fairly without undue influence. This all contributes back to that stability and validity that we talked about just a second ago with the Supreme Court and state courts listening to the Supreme Court. This is why, okay? We got to act impartially and make fair decisions without undue influence by outside forces. And we're going to come back to this point a lot as we continue on this semester. Okay. Well, that's a real quick overview of the court system. We will come back to some of these issues later on down the road as we move through the semester. Next week, we're going to be focusing on lawyers. Since we talked about courts and we talked about trials, next week we're going to be focusing on lawyers.